Welcome back to U.S.S.G channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. This video will start a new series here on YouTube dealing with career offender status or criminal livelihood under the federal sentencing guidelines. It is a rather difficult topic, but knowing my viewership, I think you guys can handle it. This first video will deal with the definition of a controlled substance offense under federal law, and then we'll interpret a state statute, section 11360 here in California, which deals with transportation or sale of marijuana. And then we'll answer the question whether that statute fits within the definition of a controlled substance offense and whether it will trigger a career offender status and the enhanced guidelines under the federal law. Today we're discussing United States versus Martinez, a Ninth Circuit case from the year 2000 that deals with a career offender status under the federal sentencing guidelines. Before we get into the law, I want to give you some preliminary information about the federal guidelines. I hope your attorney is explaining to you the federal guidelines, the federal sentencing chart that's in the guidelines, and the amount of time that you're facing in federal prison if you take the case to trial or if you plead guilty. Of course, if you take the case to trial and win, the case is over with, and the sentencing guidelines are not exactly applicable to you anymore. But if you're charged in federal court, before you make any decision, you need to understand how much time you're facing. Now, the guidelines are no longer mandatory. They're advisory. So the federal district judge assigned to your case will first calculate the sentencing guidelines, but at the end of the day, he or she can sentence you to more time or less time than the sentencing guidelines say. So it is important for your attorney to be familiar with that particular judge so he can tell you how much time you're realistically going to receive. Is it going to be less than the guidelines, within the guidelines, or more than what the guidelines say? So now let's go into the guidelines and discuss United States versus Martinez. In the sentencing guidelines, we have a chapter on career offender status. It is section 4B 1.1. The sentencing guidelines are available online. I will link them in the description under this video so you can click and read the guidelines. You can go into this chapter. But essentially, if you're charged with a crime of violence or a controlled substance offense, those particular chapters are also in the guidelines. So first, you will calculate your guidelines under the particular charge that you're facing in federal court. But then you have to look at the career offender chapter if you're over 18 years old and you have 2 prior felony convictions for either a crime of violence or a controlled substance offense. Why is that important? Because let's look at an example. If you're charged with importation of methamphetamine in federal court, you will look at a chapter on drug importation and you will first calculate those guidelines. But if you have 2 prior felony convictions for crime of violence or a controlled substance offense, the guidelines may be enhanced under this chapter 4 because you might be a career offender. In this video, we're dealing with Mr. Martinez, who says that he does have 2 drug convictions, 2 priors, but one of them, he says, does not qualify under the career offender status. He says that it should not be counted as a controlled substance offense. So first, let's define controlled substance offense under federal law. Under federal law, in the definition section in the guidelines, it says that a controlled substance offense is a prior under federal or state law punishable by more than 1 year, so a felony, that prohibits manufacture, importation, exportation, distribution, or dispensing of a controlled substance or possession with intent to do manufacturing, importation, exportation, and so on. So you're whether actually manufacturing or you're possessing with intent to manufacture. That is the definition of a controlled substance offense. But when we're looking at the priors, yes, some of my clients have federal priors, but a lot of times my clients have state convictions. So then we have to look at the state law and whether that law fits within the federal definition. In this situation, Mr. Martinez was convicted under California Health and Safety Code 11360A. So first, let's look at the statute itself. What does it prohibit? Well, it prohibits transportation, importation into the state, sale, furnishing, administer, gives away, or offers to transport, import into the state, or sell marijuana shall be punishable by imprisonment for 2, 3, or 4 years. Mr. Martinez was convicted for transportation of marijuana. That was the statute that he pled guilty to prior to this particular federal offense. And he says that transportation of marijuana does not fit within the definition of a controlled substance offense. So it should not count towards those 2 prior felony convictions. And if it doesn't, he will not be a career offender. So he will not be facing an enhanced punishment for this particular crime that he's facing in federal court. So what does the Ninth Circuit does in this case? Well, transportation, at first blush, when you look at this statute, you might think, wait a second, of course it deals with drugs, of course it is a controlled substance offense, but not so fast. If you look at the federal definition, there's manufacturing, importation, exportation, distribution, or dispensing. Wait a second. Transportation is not listed in the federal definition. So at first blush, it seems like it actually doesn't fit under the controlled substance offense. Transportation does not connote travel across the border because the statute includes importation into California. What do I mean by that? Well, the government argues that transportation of marijuana under state law fits within the federal definition because transportation can be equivalent to importation under federal law. But the Ninth Circuit says that can't be true. When we're dealing with federal law, when we're talking about importation, we usually mean within the United States, into the United States. That's the whole point of importation. Exportation would be out of the United States, and importation would be into the United States. Transportation usually deals with something within the state or within the country. And we know that the state legislatures had 2 different definitions in mind for transportation because they in fact had the word importation into the state. Why do they need to write importation into this state if transportation would have covered it? So clearly, the state legislatures thought that transportation would cover transportation within the state because importation is also in the statute. So the Ninth Circuit says that the federal prosecutor is incorrect when he says that transportation of marijuana should be covered under federal controlled substance offense. Transportation without more is not within the relevant controlled substance offense definitions. And finally, when we're looking at the statute, when we're interpreting state law, we have to have a categorical approach, says the Ninth Circuit and really the Supreme Court. What does that mean? It means that first we have to look at the statute itself, which is what we did earlier. We read the statute and thought about it. Does it fit within the federal definition? And then we can look at the judicially noticeable facts, including indictment and signed plea agreement and other documents that are judicially noticeable. Usually those are the items that are filed with the state court. In this case, Mr. Martinez was first charged with importation and transportation. But by the time his state case resolved, if we look at the plea agreement, he signed transportation of marijuana. And transportation of marijuana without the manufacturing, importation, exportation, distribution, or dispensing, if it's just a simple transportation of marijuana under state law, that statute does not fit within the federal definition of a controlled substance offense. And because it doesn't fit within the definition, it is not a controlled substance offense. And so he does not have 2 prior felonies for controlled substances, and thus he's not looking at the enhanced guidelines under Chapter 4B 1.1. I will also tell you that this definition of controlled substance offenses can be seen throughout the guidelines. One more example I can give you is if you look at section 2K2.1, the firearms section. The firearms usually we're dealing with base offense level based on the type of firearm, your status, whether you're a felon in possession or not, the type of ammunition, the type of magazines, and so on. And if you have priors, if you're a career offender, or if you have controlled substance offenses, usually you're looking at an enhanced base offense level. And again, if you look at this case, if you have a prior for transportation of marijuana under California state law, that definition, that statute, does not fit within the federal definition. So hopefully you now understand a little bit more about controlled substance offenses and the career offender status, and you can talk to your attorney what it means for you as you're facing federal charges, whether you're going to be enhanced at the end of the day, or whether you can look simply at the chapter of the section that you're charged with in federal court. I hope you enjoyed this video. Click like, subscribe, hit that bell notification button. Please share my channel with at least 2 friends. It will really help me. And I know the holidays are around the corner. If you're interested, purchase one of these t-shirts, give it to one of your friends that always gets in trouble. Thanks for watching.